claims that he thought boneless wings were real chicken wings with the bones removed. The first thing that we're getting to in food court is a story that I saw a couple headlines about. A few of you sent to me and were like, food court. And then I went to pull the opinion. And when I pulled the opinion from the court, I saw the first line of the opinion and went, oh yes, we need to talk about Buffalo Wild Wings. The judge is going to give you a background on this suit. So we're just going to let the judge do it. We are just going to trust the court for this Buffalo Wild Wings ruling. This happened February 17th, 2026. The United States District Court for the Northern District of Illinois Eastern Division. Memorandum opinion and order from the plaintiff, Amin versus Buffalo Wild Wings, Inc. From Judge John J. Tharp Jr. Memorandum opinion and order. What's in a name? If you're listening in the background, I am reading this verbatim. What's in a name? If we call a wing by any other name, would it smell as sweet? He footnoted it. The judge footnoted it. See, William Shakespeare, Romeo and Juliet, Act 2, Scene 2, 1, 47 and 48. If we call a wing by any other name, would it smell as sweet? The plaintiff says no. The defendant, Buffalo Wild Wings, BWW, sells a product it calls boneless wings, which are essentially chicken nuggets, pieces of chicken breast meat, deep fried and tossed in whatever sauce or dry seasoning the customer wants. Halim, the plaintiff, apparently found this confusing. See, I love it when a federal judge gives the levity and the weight that this lawsuit requires. He claims that he thought boneless wings were real chicken wings with the bones removed. He says B-Dub's product should be called something different. Something like chicken poppers. Plaintiff sued B-Dubs over his confusion, but his complaint has no meat on its bones. Plaintiff does not plausibly allege that reasonable consumers are deceived by boneless wings, as he has failed to state a plausible claim for relief. This particular plaintiff, when I ran this in Pacer, has more than 15 lawsuits as a plaintiff in a variety of different jurisdictions. This is not someone who was harmed by Buffalo Wild Wings. This is not someone who was like, hey, this sauce said it didn't have this ingredient in it that I'm allergic to and I was harmed by the allergic reaction. This is not that case. This is a plaintiff that is looking for tits on an ant and is like, they say that those are boneless wings. I wonder if they really are. Plaintiff brought this lawsuit for violations of the Illinois Consumer Fraud Act, breach of express warranty, common law fraud, and unjust enrichment. He says that Buffalo Wild Wings fools its customers on purpose, calling its products boneless wings because breast meat is cheaper than wing meat. What? Says he's not the only one for whom B-Dub's wings failed to quote unquote meet, spelled M-E-A-T, expectations. Judge, you're just being cheeky now. Plaintiff seeks to bring a nationwide class action on behalf of customers who were allegedly duped into buying boneless wings thinking that they were actually deboned chicken wings. How would you even debone a flat? B-Dubs seeks to dismiss the claim as an initial matter. Wild Wings argues that Inspire Brands, Inc., which plaintiff does not identify and as to which he makes no allegations, should be dismissed as a defendant, and plaintiff lacks standing to seek injunctive relief. Plaintiff concedes both points. Wild Wings further argues that plaintiff does not have standing to bring claims for damages and that he has not stated a claim under any of his legal theories. So we're in like a full 12B6, failure to state a claim for which relief can be granted. On a motion to dismiss, the court accepts the pleaded facts as true and draws all reasonable inferences. So it is based on the well-pled facts on the four corners of the document, meaning when I say four corners of the document, literally what's on the paper. So the court considers a motion to dismiss. This is pre-summary judgment. This is early on, just on the four corners. If this is properly pled, is there a claim here? And we have seen this in a lot of these suits where the court is like, you're not harmed. So there's no relief that we can grant you in court because you were fundamentally not harmed. The court does not, however, accept legal conclusions as true. Viewed in this light, the complaint must state a facially plausible claim to relief to overcome the motion to dismiss. I wonder if relief is where we're going to get in this lawsuit as well. Like, there is no relief. The court goes on to say that the Seventh Circuit has not adopted the requirement that Wild Wings advocates. To the contrary, courts in this district have recognized that plaintiff adequately alleges an injury in fact by saying they would have paid less or not bought the product absent misleading labeling. And this may need to change in the case law, truly, because is this the problem? That saying you would have paid less for it is enough to have standing? And is that the issue that the law needs to address? So the court goes on to cite case law and then says, plaintiff alleges that the wrongful act caused him to part with hard-earned money that he would not otherwise have spent. Taken as true, plaintiff suffered monetary harm, a concrete injury for Article 3 standing. Plaintiff has standing to bring the claim. So the court here found standing under the case law saying you were harmed. Not all courts agree with this, but different jurisdictions, and when we're looking at different circuits, it's going to break different ways. And then you will see plaintiffs starting to strategize where they will sue based on what the courts are doing and conversations with the lawyers. Failure to state a claim. The court begins with plaintiff's ICFA theory. An ICFA claim has three elements. Hey, we're practicing issue spotting and we're practicing proper legal argument. Look at this. What are the three elements you need to prove to have an ICFA claim? One, rule number one, a deceptive or unfair act or practice by the defendant. Two, the defendant's intent that the plaintiff rely on the deceptive or unfair practice. Did the defendant intend for you to buy it because of its labeling and pay more for it because of its labeling? Fair. Three, the unfair or deceptive practice occurred during a course of conduct involving trade or commerce. Did you buy a thing? So those are the three elements. Here, a deceptive or unfair act or practice. They're alleging it is calling the boneless wings because wing implies that it's made from a different part of the buffalo. Wait, no, chicken. Not chicken of the sea, chicken. Chicken, different part of the chicken. Wild Wings contends that plaintiff has not plausibly alleged a deceptive act on Wild Wings' part. A label is deceptive if it is likely to mislead a reasonable consumer in a material respect, even if it's not literally false. As the movement, meaning the party bringing this motion, Wild Wings must demonstrate as a matter of law that plaintiff's reading is unreasonable. B-Dubs says a reasonable consumer would not be misled by the term boneless wings because context clues make clear that the nugget cannot be made of wing meat. Plaintiff first argues in opposition that the term boneless wings is literally false because the products are not wings. The court says that's debatable. Wild Wings argues that, quote, wing refers to the style of cooking in this context, not a chicken's body part. Emily, are they going into this much depth to argue this? Yes, because losing for Wild Wings has consequences. So yes, there are lawyers sitting there literally going to work being like, what did you do today in your fancy law job? Well, I'm going to have to fight over what's a boneless wing versus what's a chicken nugget. Words can have multiple meanings. The court says, indeed, the term buffalo wing refers to the type of sauce on the wing rather than indicating it's made of buffalo meat. Yes, Your Honor. Exactly. Even if this court were to decide that the term boneless wings is literally false, it is not deceptive as discussed below. Plaintiff's arguments apply equally to cauliflower wings. There we go, chat. We got there. We got to the cauliflower wings. The court's like, oh, you want to make that argument? Great. Then your argument also applies to the cauliflower wings as Wild Wings points out in the reply at 11. Cauliflower wings are sold at Buffalo Wild Wings under the wings section of the menu and are presented as an alternative to chicken wings. If plaintiff is right, reasonable consumers should think that a cauliflower wing are made at least in part from wing meat. They don't. The court, they don't though. They don't though. Even plaintiff concedes the point, saying that cauliflower wing is clearly a fanciful name because cauliflowers do not have wings. They didn't actually, Your Honor. Did they fucking write that? This is where they hit themselves. They argued that this is plaintiff's language. Cauliflower wing is clearly a fanciful name because cauliflowers do not have wings. The court agrees. Boneless wing is also clearly a fanciful name because chickens do have wings and those wings have bones. And buffaloes still do not have wings. If you're arguing that you have been harmed by the boneless wing, you cannot then also argue that the cauliflower wings are clearly a fanciful name. Can you not see how that's going to turn right back around and smack you in the face? A reasonable consumer would not think that Buffalo Wild Wings boneless wings were truly deboned chicken wings reconstituted in some sort of Franken wing. And the court finds that as a matter of law, plaintiff's reading of boneless wings is unreasonable. And plaintiff has failed to allege facts supporting the deceptive act element of the claim. So the judge is saying, as a matter of law, no one is deceived by this. Therefore, this is not going forward. The claims for unjust enrichment, breach of express warranty, and common law fraud fail for the same reason. And that reason is that as a matter of law, reasonable consumers are not deceived by the marketing of boneless wings. Accordingly, although it is difficult to imagine that plaintiff could provide additional facts about his experience that would demonstrate that Buffalo Wild Wings is committing a deceptive act by calling its nuggets boneless wings, the court will give him leave to amend. Damn it, Your Honor, no! Outrageous. Any amended complaint is due by March 20th. Just dismiss it. Mount up and ride, Your Honor. What facts are they going to allege that's different? Lawnard, I know you have been loving the Lawnard Shop, and me too. But what you might not know is that the Lawnard Shop started way back in the day when you guys were asking, can we get shirts? And I built it at like 3 a.m. on Shopify. Shopify is the commerce platform behind millions of businesses around the world and 10% of all e-commerce in the US, from household names like the Lawnard Shop or Chamberlain Coffee and Rare Beauty. And when I said I built the Lawnard Shop at like 3 a.m., it's because they have hundreds of ready-to-use templates that make it really easy to design your shop so it doesn't feel like a template, but also you're not gonna mess anything up, which is always what I'm worried about when I'm doing things myself. And they have award-winning customer service there, just in case you're not sure. And Shopify integrates directly into social media selling. So when you click through to the Lawnard Shop on YouTube, that's all powered by Shopify. And they have the Shop Pay button that integrates into every shop, which as a shopper, I love. And I realize how many of the places I'm shopping are Shopify sites because I can just hit Shop Pay, it's getting right to me, and I absolutely love it. So Lawnard, to see less abandoned carts and more sales, now is the time for Shopify and their Shop Pay button. Sign up for your $1 per month trial at shopify.com/Lawnard. Just head to shopify.com/Lawnard to start hearing this soon. That's shopify.com/Lawnard. Now let's get back to today's episode. Second amended class action complaint from March 20th, 2026. This deceptive marketing practice defies reasonable consumer expectations. Indeed, as described in further detail below, survey research demonstrates that 43% of Illinois consumers who purchased Buffalo Wild Wings boneless wings in the past year believe the product contained only wing meat. You've got to be fucking joking me. How many people did you poll? 5? Separately, a YouGov poll of over 9,000 adults found that only 22% of Americans believe boneless wings made from chicken breast should be called wings. 42% believe they should not be referred to as wings at all. We're going to scroll and look at the survey because apparently 43% of Illinois consumers who purchased Buffalo Wild Wings in the past year believe the product contained only wing meat. That might actually get them past a motion to dismiss. They did a poll. The results confirmed that consumers are deceived by defendants' use of the term boneless wings. 43% of respondents, 172 out of 400, which is a very small sample size, believe the products contained exclusively wing meat. An additional 14% believe the product contained one or more part of the chicken. I mean, I think that's reasonable to believe, like, okay, one or more part of the chicken, fine. In total, approximately 52% of all surveyed Buffalo Wild Wings boneless wing purchasers believe the products contained wing meat. The survey's attached. 400 respondents. What is your age? Here we go. 14%, 18 to 24, 22%, 25 to 34, 22%, 35 to 44, 17%, 45 to 54, 18%, 55 to 64, and 7%, 64 and above. So that breaks down to the largest respondent groups being between 25 and 44, followed by 45 to 54, followed by 55 to 64, then followed by 18 to 24. 51% identify as female, 49% identify as male. What state do you live in? 100% Illinois. That applies because that's where they're suing. Have you visited a Buffalo Wild Wings in the past year? 100% said yes. Well, I think they got rid of everybody who didn't go to Buffalo Wild Wings. Which of the following types of wings have you purchased at Buffalo Wild Wings in the past 12 months? Traditional wings, bone-in, boneless wings, cauliflower wings. 100% bought the boneless wings. Did you exclude participants that had not bought the boneless wings? It sounds like it. When viewing the above image, what part of the chicken do you believe is in Buffalo Wild Wings boneless wings? 5% leg, 32% breast, 43% wing, 5% thigh, 1% neck, 15% more than one part of the chicken. I am still buffering that this has been refiled. However, I think with the, as much as I hate saying this, I think with the poll, they might get past a motion to dismiss, and this might have to go forward to a motion for summary judgment. Buffalo Wild Wings filed today joint motion for briefing schedule on defendant's motion to dismiss. Do you see how many law firms are involved in this? Multiple law firms are involved in this. Buffalo Wild Wings is going to make another motion to dismiss. Defendant's motion to dismiss the second amended complaint shall be submitted no later than Monday, May 4th, 31 days from the current deadline of April 3rd. Plaintiff's response to the motion will be 45 days later. Defendant's reply will be 30 days later. Counsel for the parties have met and conferred. They're going to go through all of this with the court again. Emily, when did this case get filed again? Back in 2023. It's 3 years later, and we are doing another motion to dismiss. 4 law firms are involved in trying to litigate whether or not a boneless buffalo wing is misleading. And this case is on the docket now. That's all. It's food court. It's on the docket. Why? Because this federal judge, starting his order and ruling dismissing this, quoting Shakespeare, and then saying that this case has no meat on the bone is a 10 out of 10 for me. And I'm here to see what the judge says about the next one, because honestly, the plaintiff arguing that over 40% of the 400 people surveyed were deceived by survey might be enough to get it past a motion to dismiss, to get it into discovery. And that might be enough for the plaintiffs to push Buffalo Wild Wings corporate to settle this case, to not go through the extensive discovery litigation. Then again, Buffalo Wild Wings might be like, you know what? Fuck it, let's ride. Go ahead, let's go. This is dumb. And we're not doing this. I really don't think that there is a lot of confusion. However, when you have a survey that says 40% of 400 people who have eaten at Buffalo Wild Wings in the jurisdiction in the last year thought that they were in fact deboned wings, might be enough to get past that standard for motion to dismiss. Because this court and this jurisdiction is interpreting harm as simply a plaintiff saying, I would have either not bought it or paid less for it. This is a fight over whether or not Buffalo Wild Wings boneless wings are essentially chicken nuggets. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerd.app.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.